Up next on our civil docket, we have the case of Buzema v. Chatterton, file 24-9042CZ. Mr. Curcio, you want to place your appearance on the record for plaintiffs?
Yes, Your Honor. Attorney Nick Curcio on behalf of the plaintiffs in this case.
Okay, good morning. And Mr. Chatterton, you're present in the courtroom. Are you continuing to represent yourself in this matter, sir?
Yes, sir.
Okay, Mr. Zimba, as well, you're representing yourself?
Yes, Your Honor.
Okay, and is Mr. Jangama present?
Mr. Youngma is not present.
Okay, and you're Mr. Nepomuceno?
Yes, sir.
Okay, and you're representing yourself in this matter, is that correct?
I am.
Okay. All right, I did receive a motion for voluntary dismissal with prejudice. I received a brief in opposition filed by Mr. Yangma. I think is expressing the viewpoint of the remaining defendants. Some of the other defendants have already filed a stipulation, and those parties are already dismissed. So, Mr. Curcio, do I have it right that the remaining defendants are the four that I mentioned?
Yes, Your Honor.
Okay, anything you want to say in support of your motion?
Yes, Your Honor. We largely like to rest on our briefs, but I will briefly go through our reasons for why we believe dismissal is appropriate. This matter was brought to correct wrongdoings that clients alleged were done at a convention, I believe in March of 2024. Shortly after it was filed, we obtained a temporary restraining order regarding the delegate list for the National Libertarian Party convention. Later amended the complaint to add some additional claims also stemming from that March convention. And we've been working to either bring a motion for summary disposition or try this case. Have found all the documents we would need to do that without any discovery being taken, all through internal access to Libertarian Party documents. And as time progressed, we're getting closer to the next round of party conventions, and plaintiffs have just determined it's no longer worth the cost to pursue this matter. They would like to dismiss it. They don't have any issue with it being dismissed with prejudice, and believe that since no formal discovery was taken, no substantive motions have been filed other than the one previously mentioned, believe that the defendants would not be prejudiced by voluntary dismissal, especially if it's entered with prejudice to the plaintiff's claims. In reading over the response that was filed, at least one of the responses suggested that there was a counterclaim pending in this case. I don't believe that's correct. The answer was a very lengthy, like 50, 60-page document with exhibits. And nowhere does it use the word counterclaim. The court rules pretty clearly indicate that when you intend to bring a counterclaim, it needs to state that on the face of the pleadings. The request for, I guess you would call it, damages in the complaint is based on, I think, based on the fact that plaintiffs brought this lawsuit and sought a TRO. That doesn't seem to be grounds for a separate counterclaim. It's kind of more like a frivolity type of argument. Request for, I think, sanctions would be what it would be more appropriately classified as. So we don't believe a counterclaim is pending. To the extent the court wants to make clear in its order that its order is not with prejudice to any counterclaims, we would have no objection to that. No, sorry, not with prejudice to any counterclaims that the defendants could have being brought in a separate action. We believe that would be the effect of the order we submitted anyway, but if the court would like to clarify that, we don't have any objection. And with that, I'll rest on the brief that we submitted.
All right, thank you, Mr. Curcio. Mr. Chatterton, do you wish to be heard on the question?
I believe Mr. Zimba would like to speak first, and then I would follow if that would be acceptable.
No problem. Mr. Zimba, go ahead.
Thank you, Your Honor. Well, Mr. Curcio lays out his belief and the plaintiff's belief that the defendants would not suffer harm, injury, or prejudice on account of a dismissal of prejudice. My understanding of such a dismissal is that it, broadly speaking, bars further action of this court in pursuit of this matter. If that's not the case, if indeed a countersuit relating to these matters would still be possible, then I would agree that there's a lower standard there. He does, in the motion for voluntary dismissal, note that in addition to the defendant not being legally prejudiced, that the voluntary dismissal generally does not preclude refiling. I'm not sure why then in the court rules is it stated that the typical result of such a motion is a dismissal without prejudice, but I did note that in the answer, which, as you stated, broadly speaking, is similar to Defendant Youngman's answer. I did send that in on Friday. I'm not sure if it arrived in time. Made best effort by emailing it and mailing it overnight to Mr. Curcio, which I believe USPS may have failed to deliver on that, and then also to the court arriving today. Essentially, my argument boils down to the granting of a temporary restraining order did cause significant injury. It did change our national convention and the results thereof. The continuation of the lawsuit through a presidential election cycle and addition of further party officers to the lawsuit, placing that stress and the time involved in addressing it onto their long list of tasks that we need to conduct as part of our core mission, proved an immense handicap and harm, does prejudice the defendants in the eyes, I imagine, of our party members who did not see as great a result as I dare say would have been possible had we not been distracted with this lawsuit. And furthermore, as I stated in my answers to both the first and especially the amended complaint, there are several misrepresentations, and I would go as far as to say false statements included in the new filing and the original complaint. The amendment thereto corrected a couple of them, which I noted. They were removed, interestingly. And then in the motion for temporary restraining order as well. And we, the defendants, have not had our proverbial day in court to have our answers heard. And any notion that dismissing this case and putting these claims to rest on any enduring basis, any notion that that is a just outcome for us, the defendants, I think is patently absurd. It is unjust. I view my right to free speech as having been violated by this court due to these misrepresentations presented to it, albeit on short notice, so understandable how that could happen. But I think it's fair to say the burden to properly represent these citations in their argument is on the plaintiffs if they're going to bring such a motion and a claim that they would suffer greater injury absent the TRO than we would have suffered with it made.
Thank you, Mr. Zimmer. Mr. Chatterton, do you wish to be heard, sir?
Yes, Your Honor. To follow from Mr. Zambo's statements, I would add, I think, some summary from our previous case, the 9034 case, as well as the initial filings with that to expand upon some of those misstatements and abuses of the process that we believe were used and intentionally exploited by the plaintiffs to use the court and the rulings for their political gain within the Libertarian Party of Michigan and its proceedings as well. So going back to our previous case that was closed in April, I believe your statement in your ruling was that you established that the Judicial Committee does in fact have the authority to decide on disputes of the bylaws. It does in fact have the authority to adjudicate matters that happened in the convention. But you left open the questions of the reviewability and essentially the scope of those decisions and when they might be out of bounds. We had some discussion in the previous hearing on that matter where it wasn't clear on my side with the considerations of the bylaws around that. So in the time after that hearing closed and preparing arguments for the hearing that ultimately occurred that issued the Judicial Committee decision, it was reviewed and it was established within the state party bylaws the grounds by which these decisions were within the scope of authority of the Judicial Committee on several grounds. Those matters were very clearly communicated and established in our Judicial Committee hearing, which occurred, I believe, on May 9th of 2024, well before the submission of the arguments by the plaintiffs to the court to establish, or in which their claims were made, that the decision was based on whole cloth, was based on absurd interpretations. Those were very well established and documented both in the hearing and in the opinion that were written. They mentioned also the opinion not having been released upon the time of the decision being announced. The opinion not being released to document the reasons. It indeed was released late, but with arguments in my first response to the original complaint, justifying why that was with other actions around that. So as I mentioned, the abuse of the process, I wanted to get into a little bit of the elements of that, of how we followed through our adjudication processes within the party and under the terms of our bylaws as well, referred as our contracts in this matter. This dispute occurred leading into that March 9th convention of 2024 with contention over the eligibility of certain delegates. As is called for in our processes and documented in our arguments, and as well as in the plaintiff's arguments, the dispute was raised first to the Libertarian Party of Michigan Credentials Committee. That claim was denied in that case. It was escalated to the next appropriate level at the convention floor to motion to the body. It was defeated by the plaintiffs using basically mob rule tactics, which they frequently have used throughout this entire endeavor to try to subvert the rules and the process of the party to try to push through and by misrepresenting facts of this case. Once the actions were set by the convention to elect the invalid list of delegates, it was challenged first to our judicial committee. They cited that there was initially a claim of only 4 invalid delegates at the state convention, leading to the invalidation of 5 national delegates. They omitted claims in that statement that an additional challenge, which was the basis of the disqualification of the additional delegates. That opinion is documented and cited in their own arguments. It's referred as the Miramonte opinion, which challenged the not recognizing those additional delegates from the Macomb organization. So there was a challenge to that they, whether intentionally or unintentionally, did not present to the court in their arguments to establish the absurdity of considering those delegates invalid. So after that was decided, we sent the amended list to our national party. They submitted their claims to the court. And based on the consideration of our initial submission on the challenge about only the 4, they also did not mention that the challenge of the validity was sent to our National Credentials Committee, which ultimately that ended up being the mechanism at which it was challenged after the TRO was granted against us that prohibited the defendants from arguing. That challenge had already pre-existed that case to our national credentials. And after the TRO was granted and after the revised and, in our opinion, invalid list of delegates was sent to the national party, that challenge was exercised and the National Credentials Committee agreed that the revised smaller list that we had submitted was the valid one. So going through that, they, in their submission requesting the TRO, I believe that they made specific claims that they had no other recourse to resolve these disputes other than the relief of the court. However, with the co-defendants that are also represented by Mr. Curcio in the national trademark lawsuit, they were simultaneously providing to our National Credentials Committee the arguments for not seating those delegates, essentially exercising their alternate forms of recourse to pursue that grievance, while they were, I believe, telling the court that they had no other avenues of recourse for that. So then after that convention, as I mentioned, the National Credentials Committee sided with the shortened list that was considered with the delegation that was reduced by their invalid delegates. When the National Credentials Committee report was issued to the floor of the convention, the plaintiffs and their allies presented to the convention body a claim that your ruling in the TRO was a final claim, that there was no further considerations around that. And I had intended to try to mention the citation, I believe it was in your ruling, stating that this is an open case in controversy, that it would be heard in court to further evaluate that. But the plaintiffs, following their false statements to the convention body, made a motion to close debate before that could even be shared. And at that time, because of the submission of the expanded delegate list, that even affected our national credentialing or our national convention approval process, and it substantially lowered their threshold from either it was a super majority or a 7/8 majority down to a simple majority vote to approve the seating despite that. So even after the TRO was granted against us, we pursued our legitimate avenues, not specifically the defendants, but other members of the party, to try to rectify that within our appropriate processes, and still, due to the dishonest and abusive actions of the plaintiffs by misusing the court's actions, they use that to leverage further political gain in that circumstance. So closing that up, that line of points up, I would mention additionally that as they were going through this process and making their arguments to the court, Mr. Ziemba mentioned numerous mischaracterizations that were made. It is my belief that those were not accidental miscommunications, that they were essentially at best caused by failure of the defendant or the plaintiffs to engage in these processes, which are a statement of principles, which is part of our bylaws, demands that members of the party should exhaust internal and voluntary dispute resolution processes before seeking intervention of a court. I touched on the point earlier that the arguments were made in our judicial committee hearing and in the opinion, and yet in the submission to the court, the plaintiffs did not include those informations. Whether we checked back our records, and only one of the plaintiffs even attended the judicial committee hearing. So while a claim was made, they did not participate in the process. They tried to work around it. They tried to throw the minimal amount of effort in there so that they could bring their claims to the court, and they tried to abuse the decision of the court to further their political aims in contravention of the rules and the internal processes of the party. So I don't wish to take too much time. I do have details of several of the mischaracterizations, a couple of pages worth of items. I would perhaps just mention one is some of the most critical that I believe is that in their original argument, item number 61 made several claims that our arguments from our JC opinion were made of whole cloth, as I mentioned. They even made, I think one of the more egregious lies that they stated was the claim that our bylaws do not even call for county affiliates to even have bylaws, that it was optional for them to adopt those. And I think that was one of their statements, to say that the state party did not have the authority to act through the judicial committee to decide those matters. However, as we pointed out in our arguments, I believe it was 74 in our amended complete response, I think, and 61 in our initial response, that our bylaws do not, in fact, make it optional, that they assign the choice of adopting their own bylaws or following measures of Michigan statute to adopt operating rules. Our bylaws further call for the affiliates to present a copy of their operating rules upon affiliation, and that they must adopt their own and or follow the state law. So to go back to the original decision and whether or not there could be any meritorious claim that the decision of the judicial committee was outside of the body, as I started off with the presentation, your initial ruling stated what is the context of reviewability of their decisions and the scope of their authority. After that last hearing, we looked into and found a provision from Robert's Rules of Order, and I'll wrap pretty quickly with this. Apologies for the long statement. The citation from Robert's Rules of Order is 5668, that each society decides for itself the meaning of its bylaws. When the meaning is clear, the society cannot, even by unanimous vote, change the meaning. So that effectively establishes, in my opinion, the burden that the plaintiffs needed to meet to establish that the JC did not have authority to rule on this matter with the county. So a clear meaning, a clear statement that our bylaws would prohibit the consideration of a county party bylaws in enforcing the state party rules. However, An ambiguity must exist before there is any occasion for interpretation. But where an ambiguity exists, a majority vote is all that is required to decide the question. So as you established in your first ruling, it is the domain of the Judicial Committee to decide on the disputes of these bylaws. And this standard from 5668 number 1 states that if an ambiguity exists in the bylaws, a majority vote of the Judicial Committee settles that ambiguity. So I believe it was our burden of proof, or the Judicial Committee's burden of proof, to establish that their decision at the minimum was made within the bounds of an existing ambiguity in our bylaws, and essentially that it cannot be the case that our bylaws specifically prohibit it. So to establish that, and this was documented in both of our responses to the complaints, that our state party bylaws call for the adoption of bylaws or the following of state statute for operating rules. It calls for the county party to only be affiliated if their operating rules are in compliance with the state party bylaws. Our state party bylaws establish that upon adoption of bylaws, that county parties must elect their officers according to those bylaws. Our state party bylaws further establish that the duly elected delegates from a county party may not be rejected from a convention. So emphasis on duly elected. And our bylaws clearly establish and define the responsibilities under Roberts, which is cited in the Judicial Committee decision. I think that's 59, 19 through 26, I believe, is the citation for that, but it's specifically outlined in our Judicial Committee opinion, in case I have that reference wrong off the top of my head, that our state party shall have a credentials committee that reviews the submissions from the county parties and establishes their right to be registered or entitlement to be registered, and the review of documents that they have to look at to make that decision, which includes submissions.
Can I ask you, Mr. Chatterton,
Yes.
and you know, you're discussing a lot about the merits or demerits of the court's TRO prior to the convention.
Mhm.
But I mean, that we don't have a time machine. We can't go back and undo that in any respect. And what we have now, since relief was granted as to that count by the temporary restraining order and then the holding of the convention, the amended complaint includes arguments that the defendants have breached the contract of the bylaws with regard to seating of representatives for District 8 and 10 of the party, have wrongly suspended a local affiliate status of, I think, was that Macomb County?
Correct.
And then have wrongfully removed a district representative, Dana Carver, who's one of the plaintiffs, and wrongfully replaced a district representative with a Mr. Fitzpatrick or Fitzgerald, I forget which. And that those are the live claims that the plaintiffs were suing the defendants regarding. And they're looking to dismiss those with prejudice, meaning that they cannot ever again complain about those actions in a court of law. What additional relief are you seeking?
So we
From
seek
court.
to basically ensure that our avenue is not closed to make a counterclaim or a countersuit. We've been working very hard to get representation for this case since our last hearing. We were unsuccessful. I think Mr. Zamba provided some details about those efforts of why we have not been successful thus far. We did find attorneys that would represent us in other jurisdictions. But since the case was ongoing here, we didn't have the avenue here for that. So our concern at this point is that we believe that a dismissal with prejudice could close the door on adjudicating those matters, since the consideration of the validity of the delegates is essentially the basis for all of those claims that you cited. that was, I think, a foundational event in deciding whether or not those representatives were unjustly removed or unjustly replaced or disaffiliated for the county party, that the validity of the JC decision that led to the TRO is the same question that underlies those matters. So I believe the claims for unjust removal of the district rep, as well as not seating of the additional reps, were all foundationally built upon whether or not the JC acted within its authority to decertify those delegates, because it all stems from whether or not the 13 state party convention delegates were validly seated and validly recognized at that event. The further elements, the claim of the unjust disaffiliation and the removal, I believe the basis for those arguments is that had those individuals been seated, that the vote margin necessary to do the removals and to do the disaffiliations would not have been possible to meet.
Right. So what kind, I mean, there's been a lot of reference by the defendants opposing this to, counterclaim. There has not been a counterclaim filed in this action. So I think I might disagree with Mr. Curcio that I think a dismissal of this action with prejudice may very well bar the defendants from later filing suit for a claim that they could have but did not bring in this lawsuit, including counterclaims. But let me ask you, Mr. Cheboygan, I haven't heard any kind of clear definition of counterclaim for what?
So the counterclaim that we seek to pursue is for false claims that we believe were made to the court that have irreparably damaged
that led to the issuance, that led to the wrongful
issuance
issuance
of the
of TRO.
Yes.
What remedy would be available? I mean,
Well,
like I said, we don't have a time machine remedy.
Absolutely. I think we can establish, and especially if we are able to attain representation through a different venue, we would have the opportunity to work with an attorney to establish appropriate damages. We believe that TRO constituted a violation of our First Amendment rights and that it barred us from submitting documents or arguments to argue in favor of our selected delegation list after the judicial opinion. And then furthermore, one of the key elements that we are hoping to achieve is that we believe that the plaintiffs are being disingenuous in their motive for dropping the suit. And we think we have very strong evidence of this based on their handling of the recent case of the trademark suit that they were engaged in with our national party. So if I can give a very short background on that.
There was in the written responses that an argument that the plaintiffs or people allied with them have talked about strategic dismissals or strategic rulings, and so that even though they didn't legally prevail, as a matter of political strategy prevailed.
Yes.
And so there's a concern by the defendants that the plaintiffs are going to spin the dismissal of their own action in a similar fashion. Is that, I understand?
Yes,
that
Your
right?
Honor. They did exactly that with the trademark case. And if I
But
can
isn't
just
that
read
true in, every lawsuit, once it's over, both sides are going to go out into the court of public opinion, and they're going to say the things that they want about what the judge did or what happened in the case. And that's the rough and tumble world of free speech. And I got to tell you, I've read a lot of media about a ruling that I made and think, well, gee, that's not what I ruled at all. But parties are free to say what they want about how they interpret what happened, as has happened. I mean, I make a ruling about an initial ruling about the judicial committee, which I still think is right, has the authority to issue self-executing judgments within the Libertarian Party of Michigan, interpreting its bylaws. And a state court has very little, if anything, to say about that. And I'm sure both sides went out into public or into political party meetings and said what they thought about that, as they should. And this court shouldn't really punish one side or another about what they want to say. I mean, you can go out there and say, Judge Gauthier is an idiot. You can do that. And I mean, you can't do it in this courtroom, but you can do it out there, and that's your free speech right. So what people say or think about the court rulings is always their own opinion to possess and express, right? So why should I not dismiss something just because they're going to say something about it?
So I have I think a response to that is that we believe that due to their false statements, that I think one of their core elements is that they intend to flaunt the granting of the TRO and the similar misstatements they made about even the assessment of that. So one of the core elements that we're hoping to achieve is, I think was requested, was a summary judgment or a statement from the court in some way that made clear, we believe that we have proved beyond any doubt that the JC did act within their authority in that decision. And one of the things I think we would like to see as far as relief would be a definitive statement from the court that the TRO was not justified to be granted, and that the arguments they submitted, I think, misled the court to the consideration that assessing on the grounds of the ruling regarding the Macomb delegation being outside of the scope. We believe with both the original complaint response and the amended complaint response, we've provided extensive evidence that has not been disproven by the plaintiffs in any of their filings. And even in spite of the fact that those were presented in the first response and the complaint was amended, they did not provide any refutation of those. And that was my purpose for citing the provision from Roberts, which says that when that ambiguity exists, it is the authority of the Judicial Committee to decide that by a majority vote of that body. And the grounds that are detailed in that opinion, where they stated that the Judicial Committee opinion was made of whole cloth, they had access to that information at the time and did not make that clear. So we hope to see a statement from the court that makes clear, that can be showed that we did in fact prove that that was not a valid or not a just application of the TRO against us, and that to go from there.
Okay, thank you, Mr. Chair. Mr. Nepo-Cusino, you wish to be heard on the question?
My intention is not to argue with Your Honor, but I think there's a clear distinction here. Per your example that someone in the press, for example, we had the freedom to go out, call you an idiot, quote, per your own words. I think there's a distinction here in that your, as a fellow judiciary, your relation to myself as a member of the Michigan Judiciary Committee is, I think a more apt comparison would be to yourself to the Supreme Court of the United States. If the Supreme Court of the United States had granted an injunction against yourself, that would be analogous to what's going on here. And if the Supreme Court had dismissed the case, I mean, yourself, your judgment would be left in question after the fact. Questions?
I get it's not really injunction, but there's appellate. I get appealed a lot, and I've been reversed plenty.
Yes.
So sometimes I get the ruling from the higher court, and I think, oh, okay, I got it wrong, and I'll go back and fix it now, as they've said. Other times I think to myself, well, they didn't get it right, but I have to obey what they said.
Certainly,
that happens all the time.
And certainly, and Michigan's Judicial Committee, I mean, if we did in fact commit something in error, that argument hasn't been made to us. You know, you get your opportunity to argue before the Supreme Court. The members of
I don't actually. I wish I did. I wish I did. When parties appeal,
sure,
then the judge that issued the ruling is stuck on the sidelines just watching and waiting what happens.
Sure.
If there's an appeal filed in this case, for example, up to the Michigan Court of Appeals, I'm not going to show up at the Court of Appeals and get to say boo.
Mm-hmm.
The record that we make here is my argument. Really, so judges don't get to participate in that. So, but anyway, I understand kind of what you're saying.
Yes.
But it's not a direct analogy. But I'm sorry. Go ahead. Continue.
I'll conclude my remarks there.
Okay. Yes, sir. Mr. Zimba, an additional.
I mean, just a couple more statements, since we're getting into the email from former plaintiff Saliba in the past case, stating essentially that they had not in fact lost when legally I think you'd agree they did. This is part of a pattern of behavior we've seen. I think Mr. Chatterton used the term lawfare already. That certainly appears to me to be what's going on here. And this continues, it will continue. And as Mr. Chitterton also pointed out, I have every reason to believe that any result other than some kind of scathing refutation by yourself of the arguments brought by the plaintiffs, perhaps even a sanction for all of the misrepresentations brought forth, which I think Mr. Curcio recognized would presumably be the correct course of action, were you to be convinced that that was in fact the case. And I think we've made that case thoroughly in multiple documents at this point. Anything short of that is certainly going to result in the plaintiffs continuing to plead their case before our party, to damage our cause, and to leave permanent that stain on our reputation, and leave us without recourse potentially for, frankly, as I stated, my belief that my free speech has been violated. And while I understand that you can't necessarily consider increases in severity due to a person's personal beliefs, I think you're probably aware that us being the Libertarian Party, we take that as one of our core values in life. So to have suffered such an infraction at the hands of the state, in my view, and then suffered permanent injury through the impacts that had on the result of our national convention, and frankly will continue to have with reputational damage inside the party, absent a complete reversal against the plaintiffs of some kind of disposition of this case, I don't think a just outcome has been reached. And as of the previous hearing with the summary disposition you rendered, I think in my mind that would be the ideal outcome. I've requested similar in my final response here with quantities put to the damage requests, which had not been issued previously with our answers to complaint. But I think something along those lines would offer me, myself, and the other defendants recompense for the injury that we strongly believe we have suffered. B, clear our names and our reputation and rightfully apply the reputational damage to those who misrepresented facts to this court. And finally, dissuade further such actions, bringing of more frivolous lawsuits, and disabuse any other potential plaintiffs of the notion that misrepresenting the facts of a case to a court is an acceptable form of conduct. I guess it's something of a side note, but the reputational damage seems to continue. Not that social media is the end all be all, but I happened to notice this morning when checking on my phone a notification of a reply by former plaintiff Ellison calling me a Nazi boy and pedo supporter, quote. So I don't believe these plaintiffs have any good faith toward myself or any of the other defendants in any of these actions. And I would certainly appreciate sooner than later a strong judgment against the plaintiffs by this court, or if that's not possible, then the opportunity to seek such from another court.
All right, thank you. All right, and I don't see Mr. Youngama in the meeting. I do see one of the defendants who consented to dismissal, Mr. Evans, is present in the meeting. Two plaintiffs, Ms. Thornton and Mr. Canny, are present on Zoom. One plaintiff, Ms. Carver, is present in the courtroom. They're represented by counsel. Mr. Evans has already been dismissed by stipulation, but is not represented by counsel. Just to err on the side of caution, Mr. Evans, do you wish to be heard on the question or no, sir?
Yes, thank you, Your Honor, and I will be very brief with this. So we are now 3 long years into this great battle between varying factions of the Libertarian Party. Of course, began on the national level and then, of course, branched out into the various states. So we are at a point now where, you know, for 3 years now, we've seen a lot of unfortunate choices, a lot of dirty tricks, and I think it's time for libertarians themselves to take this matter upon themselves. The Michigan State Party has a convention coming up this July, and a lot of these matters will be decided. A lot of the folks in this room will be seeking re-election to their various state party offices. And I think it's time to say libertarians have made this mess and we have to be the ones to address the mess. And I would be in favor of dismissal of this case. And I thank you for your time.
Okay, thank you. Mr. Curcio, do you have any rebuttal arguments?
Just very briefly, Your Honor, I think essentially my client agree with Mr. Evans' point and would like to move on and resolve any remaining disputes at the party's upcoming convention, which is really the motivating factor for seeking this dismissal. Just quickly, we obviously dispute that any misrepresentations were made to the court. Mr. Tatterton and the other defendants have referenced the party's bylaws and Robert's rules, as well as the contents of the JC's decision. Those documents were all presented to the court as attachments, either in this case or in the previous case, I believe in both, to the extent the documents existed at the time. So the court had a full record before it. Although this case was resolved, or the one claim was resolved on a TRO, the substantive content of that claim was extensively discussed in a hearing in the previous case before the Judicial Committee's decision came out. We essentially anticipated what that decision was going to say and discussed it on the record at length in the initial first hearing in the previously filed case. So we do think we've been honest with the court and presented a record with which that TRO was decided. As to the comments on the media, I would just note that the trademark case was settled. And I do believe that the statements that were attached as an exhibit to the defendant's filing here accurately reflects that settlement. I know that's not really relevant to what needs to be decided today. And we'll just rest on our briefs in terms of the legal argument as to why we believe dismissal is appropriate.
All right, thank you. Well, this is the second suit that I've had to adjudicate regarding disputes between various officers or members or district representatives of the Michigan Libertarian Party of the state of Michigan. And the Libertarian Party is not a named plaintiff or defendant, but all the folks involved in the case are either officers or representatives or members of that party. And the substance of it goes to some of the internal governance of that party. And should have been apparent from the first lawsuit, this court takes very seriously the idea that state courts should be very reluctant to interfere with the internal governance of political parties. And so I didn't grant any relief to the plaintiffs the first time around for that reason. And only granted the TRO because in the second lawsuit, because the actions of the Judicial Committee appeared to this court's mind to not be limited to that authority, but was reaching beyond the state bylaws into the county affiliate governance. And so then granted the TRO. Well, then we have a motion to amend the complaint that the defendants objected to. Part of the defendant's objection was that, well, we shouldn't continue to litigate all this stuff in a state court. The rules for amending a complaint are very lenient, so I granted the plaintiff's motion to amend the complaint to bring all sorts of other claims or charges that the defendants had acted unlawfully or in violation of the bylaws in the seating or removal of district representatives of the state party and disaffiliating certain local affiliates and whatnot. And, I think I expressed, if I'm remembering right, at that motion that some degree of skepticism about whether some of those claims were going to be something that this court could or should intervene about. But in any event, though, that goes forward, and then there's a long process to get people served. That's an unfortunate reality of providing due process, making sure people all have a right to be heard. And now the plaintiffs come forward and say, well, we don't want to press any of those claims. We'd rather just go back to getting out of the state court and just figure this stuff out through the political process at our party convention. And it seems a little ironic that now the defendants who said that this court should not be involved is saying to this court that I should continue to be involved. I don't want to be involved in the Libertarian Party's dealings. I don't think any state court should be tinkering with state party processes. And it was only with great reluctance that I granted the TRO to the limited relief that I thought that it granted, to allow the representatives or the delegates that had been duly elected to actually serve. And I think this case also illustrates the dangers of self-representation, perhaps. That here we have the elected officers of I would say, I think I'm on firm footing just to take judicial notice that the Libertarian Party nationally and in the state of Michigan is the single most influential third party in America. And for its elected officers not to seek legal counsel is it's their right. It's their right. But I think it's unfortunate because these defendants have engaged in what this court viewed as hyper-technical interpretations of bylaws, and yet don't seem to be engaged in a rudimentary understanding of the rules of court. For example, there is no counterclaim in this case. The counterclaim is a thing. It's not just something someone comes to court and says I want damages. You have to file something called a counterclaim and serve the other side. It's very little different than a complaint, although it's it's under the umbrella of a complaint. That wasn't filed. They say they want sanctions. They never filed a motion to ask for sanctions. These are real things and real processes. And these defendants like to quote chapter and verse of Robert's Rules of Order, but don't pay any attention to the Michigan court rules. And that's why then I think, it's unfortunate that they didn't secure counsel, because I think maybe some of those things would have been presented in a way that this court could take notice of. But as it is right now, all the rules about that you need court permission to dismiss a case once it's already kind of on the tracks. It's designed to prevent someone from saying, I'm suing you, and then in the middle of the lawsuit, I don't like how it's going. I'm going to dismiss it without prejudice and then refile it later. And then you got to go back through the whole process again. And the point of that is to prevent people from engaging in, somebody used the word lawfare. It's designed to prevent that, to say you can't just keep using the judicial process to harass and hassle people and pull the plug on the case when you think it's going badly, only to jump back in at a time and choosing that you want. And I think that the plaintiffs, maybe they'd be entitled to a dismissal without prejudice under that court rule. I don't know. I'm not asked to decide that today. The plaintiffs come forward and say, just so that there's no concern about this at all, we'll stipulate that it be with prejudice, meaning we're going to dismiss the claims that we brought, and we can never bring those claims again. In the absence of a counterclaim and in the absence of a pending motion for sanctions, that is 100% of the relief that the defendants could obtain in this suit. And so the plaintiffs are saying, we're going to give you what we want, what you want. You wanted us to not bring these claims. You wanted us to decide this within the party. Okay, we'll dismiss it with prejudice. So there being no counterclaim that was filed, no motion for sanctions that was filed. I don't think that would have merit, but I didn't have one to review, so I don't know for sure. All I have is a pending suit, and the person pressing that suit says we'll dismiss it with prejudice and without cause. That is 100% of the relief that the defendants would be entitled to at this point. So there's certainly no prejudice to them to granting that. So I'm going to grant the motion and sign the order that has previously been presented. I'm not going to tweak that order with regard to any counterclaims. One has never been filed, really hasn't even been particularly articulated what in the world that would be. I suppose if the defendants end up filing some lawsuit against these plaintiffs that the plaintiffs think is, some counterclaim that they should have brought in this case, whatever court has that, will have to deal with that. I think it may well be that any claim that the defendants could have brought in this action but chose not to are barred when the case is dismissed with prejudice. But that's a fight for perhaps another day that I hope never happens. I guess just as I'm not a member of any party, But as a citizen, it's my hope that all of our political parties would manage to not find themselves in our state courts. So I'm going to sign the order, dismiss the case with prejudice, and wish you all life, liberty, and the pursuit of happiness. Good day.
Thank you, Your Honor.
All right. Okay, we are scheduled to be in court all day a week from tomorrow on pending motions to dissolve a TRO, motion for preliminary injunction, and a show cause for alleged violations of that TRO. And in advance of that hearing, I have Mr. Delaney, your motion to exclude exhibits on a late filed exhibit list from the plaintiffs. Go ahead.
Thank you. I'll be brief. David Delaney appearing on behalf of the defendant, Mr. Hope, who's seated to my right here. Really, the question before the court is, how do I prepare for a contempt hearing without a court-ordered exhibit list? If it's late, just a little bit, I'm probably not going to object. But this was 48 days late and 15 days before the hearing. The plaintiff stipulated, the court ordered it. The court has an order in this case. And as the court noted, what's on the table here is pretty important. It's contempt hearing, dissolution of a TRO, or the request to extend that. I spent the month of February, Judge, preparing for this evidentiary hearing, which is a full day. It's a long time when it's a bench trial. The plaintiff only filed a witness list. That was his choice. I don't question whether he intended to elicit exhibits or not. I'm here today because I know the court wants order when these hearings go forward. If I wait till next week and I'm in court and he starts marking exhibits and I object, I think the court would say, this should have been brought to my attention before, which we've done. The court can look at that now. The response from the plaintiff is, well, there's pictures in the file, you can rely on those, but I shouldn't have to go through the file and figure out what's in there. In addition to that, he's saying, well, photos, but not limited to what's in the file. So I'm going to be on surprise next week when he starts showing me pictures I've never seen, and I'm ill prepared to represent my client on this contempt hearing. Secondly, videos. There are no videos in the file. He lists that as an exhibit. He also lists deeds and easements in this case. On the amended complaint and all the pleadings filed thereafter, there are no deeds and there are no exhibits. So I need an opportunity to represent my client adequately. It's malpractice. If I don't prepare for trial, I can't when I get a witness and exhibit list 15 days before the hearing, which I would not have gotten if I had not filed this motion. So,
okay, I ask you, Mr. Delaney, yes. Then, I mean, some of your remarks go to the sufficiency or deficiency of the late filed exhibit list in any respect when it just says videos or something. But can I ask you if I'm persuaded by your argument that that it wasn't filed on time or within a reasonable time frame to excuse that, would it be reasonable remedy to grant your motion in part, but limit the exhibits to anything that was previously attached to pleadings? So if I were to not allow even those things to be presented, which have already been provided to you, would that be relief that would go too far, would be too drastic of a remedy? And I wanted your thoughts upon that.
I mean, that really is the good question, Judge. The good cause, I don't think he has the good cause. If he doesn't succeed on good cause, then he never gets to unfair prejudice. I think that the unfair prejudice question is what the court's really asking me. Look, the photos were already attached. Is it really unfair prejudice in this case? I think that's a finer question for the court, one in which an appellate court might look at that for an abuse of discretion. But I certainly would oppose that, but I understand the merit of the court's question. So then I'd like to fine tune that if the court's considering that. It would only be photos that are in the file. They're in the amended complaint, it references a deed and an easement, but they are not attached. So I don't want to see easements and deeds on the day of trial next week. There is an easement and a deed in the first complaint, but that was superseded by the amended complaint. So does that allow to wash into this case? And in any event, there are 3 easements. He only has 1 attached. So I think the answer to the question is that the court ordered an exhibit list in January. If I had that, it prejudices me because I lost the month of February to not prepare.
And thank you. Mr. Toganoff, your response, sir?
Thank you, Your Honor. Did the court receive my response?
I did.
Okay. I don't like to stand before the court or my clients and admit I made a mistake, and that's what happened here. When we were here last, my understanding of what Mr. Delaney had requested, and I haven't gone back and looked at the record because at this point it's moot because of the written order. But I understood that what he was requesting was witness lists to be disclosed. And I did, despite what counsel says today, we did timely file the witness list. Counsel timely filed his witness list as well. I didn't receive an exhibit list. And again, they can choose not to introduce any exhibits at the hearing. That's certainly their right to do so. I only bring that up because that obviously would have prompted me to do some digging to see why are they filing an exhibit list. That's normally not what's done with respect to preliminary hearing, and therefore look at the order and see that it was put in the order that exhibits list would be filed. When I did receive this motion, within minutes, I prepared and served on Mr. Delaney an exhibit list. It's false to say to the court that without the filing of this motion, there wouldn't have been an exhibit list called in 30 plus years of practice. What I would have expected is contact from counsel. But it is what it is, and gamesmanship is gamesmanship. What I'd ask the court to do is to look beyond the gamesmanship and look at what really is the issue here is ensuring that there's a fair hearing next week. The idea that the filing of the exhibit list 15 days before a preliminary hearing constitutes prejudice. They haven't shown any prejudice to this court. This case from the beginning has been prefaced upon actions by Mr. Hope, upon this easement. He's the one that conducted the actions. There certainly can be no surprise that Mr. Kopp and Mrs. Kopp have been making photographs and videos of Mr. Hope's actions since the very beginning. He's now gone to giving the middle finger to the camera whenever he goes by. So there's certainly no surprise, no prejudice that what we intend to do at the hearing next week is to show what Mr. Hope has done upon this easement. With respect to Mr. Delaney's claim that not knowing exactly what photos or videos would be utilized, the court's order drafted by Mr. Delaney didn't require us to give copies of the exhibits themselves. What it required was a copy of the list be filed and be served, and we've done that. I regret, and I apologize to the court. I apologize to Mr. Delaney. I certainly apologize to Mr. and Mrs. Kopp about my error. And that's all that it was, Your Honor. This is not a situation where there's been any other violations, where there's been any gamesmanship on my part, try to hide the ball from Mr. Delaney and Mr. Hope. Again, within minutes of getting the motion, I filed an exhibit list. So
can I ask you then, Mr. Toganoff? I mean, I take your point about the specificity of the exhibit list because this isn't, although it certainly is an important evidentiary hearing with regard to contempt and whether there's a injunctive relief that will continue during the pendency of the case. It's not the final hearing on the case. And so at the end of a case with the bench trial, through the discovery process, the exhibits would have been exchanged photograph by photograph. Sure. And all of this. And that's not really how it works because it can't really work that way at a pretrial evidentiary hearing. So I think the argument about, well, it's too vague just to say pictures, I'm not sure what I think about that in a pretrial hearing stage. But if I'm going to be holding a lot about this case is holding Mr. Hope accountable for what the court orders say. And it might be strange for me to then say, but the plaintiff's going to get a pass on what this court order said. If I were to grant relief, but limit it to anything that was not previously attached to any pleading in this case, including from the initial complaint onward, anything that's already been exchanged is certainly not unfair know that you might encounter that. As I try to fashion what is the appropriate remedy, are you able to articulate what kind of prejudice or harm would flow to your clients if I were to enter an order to that effect?
It would limit the more recent incursions and use upon the easement. What I would ask the court to consider is a monetary sanction to sanction me. Mr. Delaney had to file this motion. Obviously, we had to be here anyway for the pretrial conference. But I think that the best remedy would be a monetary. I've never asked the court to sanction me before, but I think that would be something that would enforce the court's order, not asking for a pass. While I believe in my practice, the way I like to practice, that just reaching out to me and saying, hey, are you not using any exhibits before you file a motion? I mean, in Oakland County, you can't file this motion without reaching out to the other side to seek concurrence. Had that occurred, he would have had the exhibit list. We'd still have the issue about it being late. But I think that fashions a remedy where Mr. Hope is not paying for Mr. Delaney to file this motion. The cops are not harmed in preparing their case and presenting their case to the court. And the court's order is enforced. My career, I'm not big on courts not enforcing their orders. So I feel that would be a fair response. That lays the responsibility for this where it belongs, upon me, not upon my clients. With respect to the court's question, with respect to the photos, that would be my concern, is that there has been activity that occurred since the last filing where we had photographs provided to the court. I think it would be important for the court to know that this isn't something that just stopped months ago. It has continued forward. And then I do want to speak just on a very briefly related issue Mr. Delaney raised about whether or not exhibits were attached to the original complaint or the amended complaint. When we're talking about this, we're talking about notice. Again, just smacks of gamesmanship to say if it's attached to the original complaint, then somehow I don't have prejudice, but but if it was, or I'm sorry, the other way around, if it was attached to the amended complaint, then my client wouldn't have been prejudiced, but since it was attached to the original complaint, there is prejudice. I mean, that's doesn't have much validity. At some point, we just try to get it right, Your Honor. I think that's what I've spent my career doing. I know that's what you're trying to do, and I think that a monetary sanction would get it right. And that's what I've asked the court to do.
Okay, thank you. Mr. Delaney.
Judge, money does not cure the prejudice. An attorney fee or a cost or any amount of funds, it's protecting my client from a claim of contempt of court. My exhibit list is witnesses and exhibits, and he would have received that. He would have seen that there were exhibits there. It's not my endeavor to contact counsel and ask him what he intends to produce at an evidentiary hearing. I think he knows this case well.
Right. I mean, but you'd acknowledge that it happens a lot, and most of the time, attorneys and judges sort of smile upon that sort of communication rather than filing motions. Right?
How do I know how he's going to present his case? He has his witnesses listed. He has zoning officials that are going to be coming in. I think that he would be aware that he signed the court's order that would require an exhibit list.
Can I ask you then, as there clearly was a violation of the court's order. No question. And Mr. Talganoff falls on his sword and says it was just an error. So there's no excuse that he's presented for it. But this court does have to consider several factors in fashioning an appropriate and just remedy. So I want to hear your thoughts about how I should consider the fact that the deadline was January 21st. And then I have a representation that's not rebutted, that you didn't reach out to Mr. Telganoff and then waited until March 7th to file your motion, essentially removing any ability he had to cure the error or any ability that I might have had in February to fashion a remedy that would still keep us on track. What am I to make of that?
It places the burden on me to navigate his case. We spent, my client and I and my other witnesses, time going through all of this file, and he filed a witness list. I then sent him the court order. He signed it. He then saw my witness and exhibit list. In the month of February, mid-February, he filed another motion to have an earlier court date, and more photographs were attached to that. It then occurred to me, are we going to be at a hearing in March on the 25th in which he starts to mark exhibits? I must protect my client from that. I've had plenty to do, Judge, on my side of the equation to get ready for this hearing. I have to defend the TRO. I have to defend the show cause hearing. I even have to defend the allegations today. And to have me go into the plaintiff's case to determine whether he's going to list exhibits or not is really outside of the province of what my obligations are to the court and to my client. And to suggest that it was gamesmanship on my part, I mean, consider this. Today he's saying he's giving the middle finger, he's just an unreasonable neighbor. Well, if that's the case, then list those exhibits. This is their case, their show cause, their TRO, their complaint. I don't have a counter complaint in this case. If what Mr. Hope is doing is so serious and so violative of the court's order, then simply produce that evidence. No different than a criminal case. If you've got him, if you've got the pictures, then give those to me. A witness and exhibit list couldn't be more rudimentary in this case. And it was not in my province. He's suggesting I did this on purpose. He didn't file the exhibit list, but it's on me to contact him and ask him, what kind of proofs will you have? I'll say this directly. Had he filed that exhibit list, even late, even early February, I would have called him and said, produce those exhibits. Let me see exactly what you have so I can defend this case. If the court's going to fashion the remedy that it's limited to what's in the file, then that will be the ruling of the court. But we can't go beyond that. I can't get a picture he took yesterday or a picture he's going to take tonight and be able to defend that. I need to have that now. So if that's the court's remedy, we don't want the money. I just want to be able to defend him at a hearing. And I certainly, and the final remark is this. At the January 14th hearing, the court promptly pressed us for preparation within 7 days. That was very quick. That's because you wanted us to put our cards on the table so we'd be ready for this hearing coming up in March. And that didn't happen. I complied with the court order. They didn't. But I have plenty to do to prepare for this hearing, and now it's within a week. So to size up the court's statements today, if the court is inclined to limit it to what's already in the file, then that's the ruling of the court. But I can't have anything new next week that I'm not prepared to defend. Thank you.
All right, well, this case is in a pretrial posture. We have a motion hearing next week scheduled for a full day of proofs. The defendant's motion to dissolve a TRO that was entered some time ago. A motion, and then the plaintiff's motion to, I guess, ripen that TRO into a preliminary injunction. And also a hearing on whether to hold Mr. Hope in contempt of court for violations, ongoing violations of that order. You know, I think both sides have kind of put me in a tough spot here because on the one hand, this TRO was entered some time ago, so it's really pretty unfair. One remedy that a court can fashion for a violation of a discovery order or a scheduling order is an adjournment. Well, that would be decidedly unfair to Mr. Hope to say, well, now you're still going to live with this TRO longer. I don't know whether he's going to prevail at that hearing or not. And if he does, then the TRO will be dissolved. So I really shouldn't delay it more than we've already delayed it. Mr. Talganoff makes a good point that the nature of the witness list for a pretrial hearing, I think, is a little different than an exhibit list. Did I say witness list? I meant exhibit list. The nature of an exhibit list before a pretrial hearing is a little different than the nature of an exhibit list before a trial. But Mr. Delaney makes a good counterpoint to that, gee, back in January, I said, file this in 7 days. The only reason to do that is so that everybody's got everything well in advance, so that we're not just kind of figuring this out on the fly next week. The case already seems complicated enough without having to do that. Another point though is I think Mr. Delaney's put me in a little bit of a tough spot here too by the delay in the filing of the motion. I mean, he's right as a technical matter that it's not his job to police the plaintiff's compliance with orders, but also then, to wait till the last minute and then ask me for relief when really there's very little relief I can do at that point other than exclusionary relief. It doesn't necessarily smack of gamesmanship, but it smells a little bit that way. But in any event, and also, the whole case is about Mr. Hope's compliance with this court's previous orders and rulings. So it does seem strange for me to tell Mr. Hope, you got to comply with my rulings, but we're going to wink at some other rulings. So I think on the balance in the exercise of this court's discretion, I don't even necessarily love this remedy myself, but I do think on the whole, it's a fair balancing of the various interests here. Mr. Delaney, I'm going to grant your motion in part and exclude any exhibits from the plaintiff at next week's evidentiary hearing, except any exhibits that have been previously attached to any pleadings in the case and exchanged to the other side. If that means that there's more recent violations, I suppose that's not in the interest of judicial economy, because there may have to be separate affidavits for a separate show cause for newer violations. But I think on the whole, that's the balance here. We're in a situation where the tail is sort of wagging the dog in this case. We've had so many procedural stuff going on. And I mean, Mr. Hope's represented by counsel, so I don't expect him to talk at any of these hearings, but I just hope Mr. Hope understands that whatever the perceived merits or real merits of this court's previous ruling, that he can't operate that business out there. That's the court's ruling. If he's not obeying that ruling, he may, by procedural wranglings, delay the day of reckoning, but he cannot avoid that day of reckoning. And this court's orders must be complied with. And I sure hope that Mr. Hope is doing so. If he has not done so, that he understands that he should start doing so forthwith. And I'm expressing no opinion about whether he has or hasn't. I'm just saying I want to be very unhappy if it ends up months into this that he's basically thumbing his nose not at the cops, but at the court in terms of ignoring its rulings. So anyway, that's the ruling on your motions.
Thank you.
Thank you.
All right, so we're also here for a pretrial. Does it make sense to do that today? Okay, we're all here.
Well, I was going to say, if I think you wanted to get a response from that. If a preliminary injunction is granted, then the trial has to be held within 6 months, I think. But in any event, does it make more sense to have the hearing next week and then have a pretrial, even at the conclusion of that hearing? And then you know where you're going with it. And
Maybe. Okay, let's just do that.
right.
Let's just continue the pretrial to next week's hearing and talk about that at the conclusion. If I take it under advisement, I guess we'll have to do something different, but we'll see. We'll see where we're at after.
Okay.
All right, thank you all
Are
very
we
much.
here at district court?
I think we are in district court next Tuesday. Yes, district court.
We'll see that. Thank you, Judge.
Okay, thank you. Obviously, to submit an order under the 7-day rule would be tricky, but you all know what my ruling was.
Yeah, right. I'll bring it next week.
Okay, thank you.
Thank you.
Thank you, Russ.
And our next case is Sunrise Resort Association v. Cheboygan County Road Commission, file 20-8790 ND. Counsel, you want to state your appearances beginning with plaintiff?
Yes, good morning, Your Honor. Philip Ellison, appearing on behalf of all the plaintiffs, as well as, I guess technically a proposed substituted plaintiff when we get to that issue later this morning.
May it please the court, Bill Henn on behalf of the Cheboygan County Road Commission.
Okay, I do see in the waiting room a Matt Hall. Is he associated with this case on either side?
He is the manager of the Road Commission, yes.
Okay, let me admit him into the Zoom hearing. All right, we've got 4 motions up. The defendants long ago noticed a motion for summary disposition and also for in the alternative dismissal as a sanction. We also have the plaintiff's motion for leave to file a second amended complaint, and then if that's granted, a request for additional discovery then on that question. You know, as I tried to think through what should we argue first, they're all kind of wrapped up together in one warp and woof. So I guess I'd propose I hear from both sides about all of this, and I'll give maybe both of you a chance for a rebuttal argument, just to be abundantly fair. Does that sound all right to you, Mr. Ellison?
That sure does, Judge. Anytime anyone says go, I'll go and start talking.
Okay, Mr. Henn, does that sound like a good process?
That's fine, Your Honor.
Okay, you were the original moving party on the first filed motions. I'll let you go first.
All right, thank you, Your Honor. Again, Bill Henn on behalf of the Sheboygan County Road Commission. As the court noted, there are 4 motions up for hearing today. 2 of them were filed by the Road Commission. 2 of them were filed by the plaintiffs. You know, and I think the court's right. They are all kind of intertwined. And for that reason, I'll start with the plaintiff's motion to amend the complaint and to extend discovery, because I think depending on what the court does with those motions, it really changes the landscape as far as the Road Commission's motions go. So I mean, as the court's aware, and I think we laid out in our motion for sanctions, this case has been remanded from the Court of Appeals since the fall of 2023. At that time, the plaintiffs were discussing their need to amend the complaint. There were scheduling orders that were entered. There was discovery that was issued by the Road Commission. But from the plaintiff side, nothing happened. No amendment to the complaint was ever made. The deadlines came and went. The Road Commission diligently pursued its discovery. But plaintiffs repeatedly missed the deadlines that they themselves had even agreed to. And so it put the Road Commission in a position where by late August of 2024, it had literally had no participation from the plaintiffs except requests for extensions, which the Road Commission was very flexible with. I mean, we worked with plaintiffs' former counsel as much as possible. But at the end of the day, these deadlines came and went, and there was no meaningful participation by the plaintiffs whatsoever. But the Road Commission understood that it was under a deadline and it needed to present a defense. And ultimately that culminated in the Road Commission filing a summary disposition motion based on an affidavit from numerous, affidavits from numerous experts that it had retained. And, you know, basically Road Commission tried to notice that up for hearing. And in that process is where the substitution of counsel happened, where plaintiff's former counsel asked the court to withdraw. But, you know, from the Road Commission's perspective, for the plaintiffs to now ask for leave to amend the complaint and for additional discovery is beyond the pale. And, you know, I find it rather rich that in reading the plaintiff's counsel's response to the Road Commission summary disposition motion, that I'm accused of misleading the court and misrepresenting things to the court like some magician on a stage, because I didn't anticipate and respond to arguments that plaintiff's new counsel is raising for the first time and wants to assert in an amended complaint. So, you know, I think that was inappropriate. I don't think that argument should be well received by the court. But you know, what it comes down to is that the amended complaint adds factual allegations. It adds an entirely new theory, which is inverse condemnation. It adds a new plaintiff, which is really, I suppose, just a substitution, because I believe Ms. Carr is the successor to Mr. Brakovich, who was an original plaintiff. But the law that we cited in response to that motion, particularly Weimers v. Cara, which is a 1997 appellate decision, says, you know, a party can't wait until discovery has passed, a summary disposition motion has been filed before introducing new theories, because doing that is unfairly prejudicial to the party that did what it was supposed to do and built up its case as best it could, despite you know, the lack of participation from the other side, and filed a dispositive motion. So, you know, Your Honor, we understand that the court has very broad discretion in how it controls its docket, and with respect to motions to amend the complaint. You know, we think that this case is just a bridge too far in terms of allowing the plaintiffs to, you know, essentially go back to a point where we were at least 2 years ago when the case was remanded, you know, November of 2023. We're coming up quickly on 2 years since then. And, you know, aside from the substantive prejudice to the road commission, there's real financial prejudice here too. I mean, you know, the plaintiffs want to hit a reset button, but what about the effort? What about the time? What about the expert expense, the attorney's fees that went into the road commission, bringing the case to the point where it is now, which is, you know, after discovery has concluded, it's, you know, time for dispositive motions. If plaintiffs are allowed to hit the reset button and amend the complaint, and, you know, also reopen discovery, I mean, I'll include that motion now as well, because, you know, if they amend the complaint, then naturally, of course, they contend that they're entitled to discovery. You know, and this is discovery that could have been done before that wasn't. But if all of that is going to get reopened, then at a minimum, the road commission should be, and the court should sanction the plaintiffs for the costs involved, the expert costs and the attorney's fees involved in drafting the summary disposition motion, which, you know, essentially, if plaintiffs are allowed to do this, they're pulling the rug out from underneath, you know, what I believe is a well-crafted defense to the existing complaint. And so, you know, at a minimum, we would ask the court to protect the road commission in that sense, if it chooses to exercise discretion to allow an amended complaint and a motion to extend discovery.
Can I mean, with Mr. Henn,
you may.
Aside from your arguments about the timeliness or untimeliness of a motion to amend past the deadline, I think was a year ago, you're asking me to dismiss the case on summary disposition, and under that court rule, aren't I required to give the plaintiffs an opportunity to amend the complaint unless such amendment would be futile? And what would you want to say about that question? Is this amendment futile?
Well, Your Honor, in a normal case, I suppose, you know, courts look favorably upon the ability to amend, but this is nothing like a normal case. I mean, this is not a summary disposition motion that was filed after, you know, the parties went through vigorous discovery, and, you know, it was discovered that in that process that there was something new, or that the pleadings had to be amended to conform to the evidence or something like that. This is not that. I mean, we're asking for summary disposition based on the merits, based on, you know, our experts' unrebutted testimony, and frankly, Judge, I think the plaintiffs admit that in their response. I mean, when you look at their answer to our summary disposition motion, there's nothing.
They kind of changed the theory, right? They say, well, all the work on the culvert and the extent to the changes to the culvert, and the length and the Well, yeah, that doesn't matter anymore, but that was sort of the case, right?
Well, that's what we thought the case was, but now again, there's new theories that are being asserted that it certainly would have been nice for the road commission to know that those theories were being asserted so that we could include them in our defense. But again, this is why I take a fair amount of umbrage at the plaintiff's response to our summary disposition motion, is that they've characterized that as me performing some sort of magic trick for the show, when in reality, those theories had never been, the theories that we supposedly are distracting the court from had never been advanced in any meaningful way by the plaintiffs. But, I think when you look at their response, I think it's clear they know that they cannot overcome the road commission summary disposition motion with what they have. Which is zero expert testimony. We tried to depose them, the plaintiffs. We were never given dates. They literally have nothing in the record with which to overcome the road commission's motion, except promises. Here, Your Honor, is what we think, if we're given discovery, we'll be able to prove. And, and Mr. Ellison signed an affidavit saying, here's what I think I can do as their attorney. I don't think an affidavit from an attorney promising to develop a case that would defeat an otherwise well-supported motion has ever cut it in terms of showing a genuine issue of material fact. It's just all speculation. It's not admissible. The court rule that the plaintiffs rely on says a party may file an affidavit showing that there are other facts, but presumably that party is competent to testify to those facts. This is not a party affidavit. This is a party's attorney's affidavit. And, I think when I look at their response, there's nothing that they can do to address the merits of the road commission's motion. And so they have, in keeping with the magician theory, I'll say, this is more like a game of card Monte than it is a magician performing a trick, because, the plaintiffs are saying, oh, well, it's not this anymore. Now it's this other thing that the road commission didn't anticipate, and shame on them for not doing that. I hope the court can see through that and see beyond that. But given their response, I don't feel the need to go through the motion, because I think, at its core, their response is, we don't have anything now to overcome this motion, but we think there's stuff out there, so we should be given a chance to develop it. The last thing, I suppose, is we have a motion for sanctions, which is independent of all of this. The motion for sanctions was based on plaintiffs' failure, at a time when they were represented by prior counsel, to answer the road commission's written discovery, which was due, or I think was submitted in February of 2024. And by roughly May of 2024, we didn't have any response from them. We gave them voluntary extensions, which they helped select the dates, and they made promises at that point that they were going to respond, and yet there was nothing. There was never a written request. We actually went so far as to get an order from the court in May of 2024 compelling them to provide responses within a certain number of days. That didn't happen. So they are clearly in violation of stipulated orders, of orders that the court entered, compelling discovery. And I think all of this just goes to show how much effort the road commission has put into the case to this point, and how little effort the plaintiffs put into it in response. And now they're asking the court for, a massive bailout, hit the reset button and take us back to, effectively January of 2024. And all we're saying, Judge, is that you can't do that without prejudicing the road commission, I believe, both substantively and financially. And, at a minimum, there should be some consequence for the repeated failures. This is not just one failure. You look at that Dean case about, motions for sanctions. Were there conscious violations? Yeah, there were multiple conscious violations. We worked with plaintiff's counsel, giving her at the time as much space and time as she needed. And it was just an abject failure, no matter what was discussed. So yeah, conscious failures, repeated promises, violation of a court order. There's 3 of the four criteria under Dean. The last one is, is the defendant, is the road commission harmed in the preparation of its case? And I think that's obvious, because as a result of all of this, we filed a summary disposition motion in the dark based on what was alleged in the first amended complaint, because that was the best information that we could get from the plaintiffs. They wouldn't elaborate. We couldn't get them to elaborate. And now they're begging the court, basically throwing themselves at the court's mercy, to give them an opportunity to develop the case that should have been developed before and wasn't, to the detriment of the road commission. Financially, substantively, more time has passed now, which, as we all know, evidence, especially evidence in the field, can change with weather conditions. I mean, I just think, although, Your Honor, to get back to the question you asked a long time ago, aren't you supposed to give them the opportunity to amend? I would say, it's within your discretion, and maybe there's a preference for that in a normal case, but this is far from a normal case. And I think I've covered all four motions. There's been a lot written. A lot of trees have been sacrificed in order to get the court up to speed on all of this. And I know you read everything, Your Honor. So, I'm mostly interested in what you have to say rather than, what I have to say. So if you have any questions or any additional questions, I'm happy to answer them as best I can.
Thank you, Mr. Henn. Mr. Ellison?
Yes, thank you, Your Honor. Good to see you again. It's been a little while. I guess I'm going to start with, and I don't like doing what I'm about to do, but I have to do it, is I can't speak for the sins of the previous plaintiff's counsel. I can understand Mr. Henn's frustration. I've looked at the file myself. I was brought in basically at the point that the motion for summary disposition was filed, and I could sense the frustration, and I think justifiably so, that could sense the frustration of the fact that prior counsel didn't do as a bang up job as she should have done. There's no doubt about that. Okay.
Well, can I ask you, Mr. Ellison, that
Yeah.
in a broad picture about that, and again, there may well have been some health issues involved that were discussed by that attorney, but then she didn't get out when maybe she should have. And I've had, some cases that you've litigated in front of me. So I take your statements that, well, I'm in the case and I know how to litigate this and I'll do it right. I take that at face value as true based on my experience with you as an attorney. But doesn't Mr. Henn have a valid point that this burden for the predecessor counsel not litigating the case for over a year, doesn't this fall on the plaintiffs, not on the defendant? And the defendant pursued this case. I have to make a confession. I don't always read every word of every exhibit in these motions for summary because they're pretty voluminous. I dip in as I think I see fit. I read them all in this one because I thought I kind of want to understand how in the world did the miniature Grand Canyon end up in this yard? I see the pictures and they're striking. But I read a report from a hydrogeologist that sounds like a super impressive guy explaining to me, here's how that could happen. Here's the mechanism by which that could happen. And it had nothing to do with what the road commission did. I read a affidavit from a civil engineer. I read something from the surveyor saying, I looked at this and the topography isn't changed from what I noticed before. I see all this stuff that they've come forward with evidence. And then if the plaintiffs, have lost the case because of what their attorney did, perhaps they have a remedy against an attorney, but at some point the defendant's off the ropes, right?
I will represent to the court. I mean, as an officer of the court, I have an obligation that if I am shortcoming in my duties and my responsibilities to the court, I should alert the court to those problems as soon as they arise, and also ask for an appropriate relief, which may include up to withdrawing from a case in a timely fashion. And again, I start with the proposition that I can understand Mr. Henn's frustration looking at this. But you asked me the question you asked me, does this fall to plaintiff? And I think the real answer is that I think if there is to be a punishment doled out, it should be to plaintiff's counsel, not to plaintiffs. As I've represented the court, everything I've asked of the clients in this case, they have come through for me in flying, timely and appropriate fashion. They've supplied me with all the documents. The shortcoming, and I don't like throwing any sort of counsel under the bus in any circumstance like this, but the reality is that I think this squarely falls on prior counsel. And the court does have the authority under its rule not to sanction the plaintiffs, but the plaintiff's counsel in that respect. And so I can't speak at this point right now as to why, I mean, I've been told as to why prior counsel didn't do the things that she didn't do. But in the reality is that ultimately the whole point of all of a court case is to reach an ultimate justice on this. And the justice, I think, in this case mandates that the court give me, and I do appreciate the kind words the court says about me in that respect. And I can give my court my assurance that when I'm on a case, and I think if my track record in front of you, just you alone is any indication, there's no shortage of me coming in and taking over a case and pursuing it with the normal dispatch and vigor that it requires. The difficulty I'm struggling here is
on the merits, though. I mean, I'm kind of stuck on this motion for summary disposition because,
well,
I read all those attachments, and this was a remarkably meritorious motion for summary disposition in my judgment, saying these plaintiffs say what we did out there caused flooding on their property. And here's a civil engineer, here's a surveyor, here's the road commission folks out there, and here's a hydrogeologist explaining, no, that's not what happened. And here's a scientifically reasonable mechanism for how that could have otherwise happened. And then in response from the plaintiffs, I have an affidavit from one of the shareholders of the company saying, this is what I think might have happened. And an affidavit from you saying, this is what I've been told might have happened. And I don't have any affidavit from any scientist or anybody explaining what would be the mechanism for that to have happened. That strikes me as just crying out for summary disposition and put this case to bed. Why am I looking at that wrong if I am looking at that wrong?
For two reasons. First of all, and this is the weaker of the two arguments first, is that this case hasn't been developed by me as part of this court case. And from what I've come to learn about this court case, and as the court knows, I handle property and complex property issues of this nature. The reality is right here is that these sorts of things should have been done by prior counsel at a sooner basis. That said, setting that aside for, because I think that goes to the issue about the delay and the sanctions that Mr. Henn has been asking in this respect. But going to the real substance of this, and of course the court knows me well enough to know, and I was using the analogy of the left hand, right hand of the magician. That was not to be disrespectful to anybody in any way, shape, or form, but to make an analogy that so much attention is being focused on the diameter, or excuse me, the length of the pipe itself that got extended, that it missed the bigger picture and the more important and relevant inquiry in this case, which the experts did not address, which is what happens if you have a 24-inch main, right? A 24-inch pipe, and for years, only the 2 bottom or 3 bottom inches of that pipe is used to push water from one side of West Burt Lake Road to the other side of West Burt Lake Road. And then, because of the way you've redesigned your drain system in that area, adding more corrugated metal piping, removing the flow valve that was on there, as well as changing the topography of the area, suddenly you've got tons more water coming into that particular area. And instead of using it in the traditional 60 years of the 2 or 3 inches along the bottom of that 24-inch, you now have 20 inches of water going at a higher rate of speed. It's not the size of the pipe that matters. And I know the tremendous amount of resource went into the discussion about the size of the pipe or the length of the pipe. That is misdirection. That is a different question than what's here. The theory of the case, at least as I understood it, and certainly how I'm pursuing it, is that the question is does this system discharge water at a higher rate of speed or at a higher velocity from one side to the other? And it's, as I read the allegations and as I've talked to my experts on this and looked at the materials that I have in this respect, it's the redesign of the road from the bike path, as well as adding more drainage systems in the area to flow water at a greater physical, geographical area at farther distances, to aggregate that water at that culvert and then discharge that higher water at a higher rate through the culvert on underneath of West Burt Lake Road and discharge into plaintiff's property. That's why you get, and I like the way you called it, because that's about the way I think of it as, is it's a mini Grand Canyon. Something sure as heck had to have happened wrong to have that amount of damage done in one singular event. And the reality is that it's because it's not the pipe that's the problem, it's the drain system that's the problem. And I think that, and unfortunately, I came into this court case after discovery had closed, after the motion for summary disposition had been filed. There are certain materials that if I'm not permitted to be able to access those, I can't defend this case. There's just no way I can go forward and to be able to defend this case, because the materials that are necessary, I believe, are in the custody and control of the Road Commission and should have been sought and secured by prior counsel and has not been. Case in point, one of the best, I think the best one is that you have an affidavit. Of course, I'm not from Cheboygan County, I'm down here in Saginaw County. But one of the things that the resident up there, Mr. Kiefer, offered is that he was informed by Road Commission staff that the flow valve system was removed from that drainage system. Well, a flow valve would control the amount of water going through that culvert pipe into the plane to make it in a normal, orderly fashion. So again, if the pipe is 24 inches, but it only lets through a certain amount because of these control valves, for example, that would, the size or length of the culvert or the extension piece would become legally irrelevant, which is what the Road Commission, I think, based their entire argument on. Again, it's not, so I need more material to be able to explain to this court and to be able to prove to this court that it's the change of the system itself it actually led to the mini Grand Canyon being imposed and cut into the plaintiff's property. Now, I've read the expert reports that defendants or that the Road Commission has put forward, and I don't dispute they're very learned men. I know some of them I actually know. I don't know if they know me, but I know them from their work, and there's no doubt that they are wise individuals. But they've been called upon to answer the wrong question being asked of them. They focus their efforts on about the pipe size. And again, that's not the heart of what's at play here. What I also need from the Road Commission is, in addition to the flow valve, sometimes they're called the check valve, there's different names for these kinds of things, is that the Road Commission, from what I have seen of the area myself, looking at maps of the areas, that the topography has been changed by the Road Commission. And of course it's been. Because now they have, in addition to a road, they now have a bike path that's there that they have to protect from washout from this water in the area. In addition,
well, sure, but that's been known, that's been known from the beginning, and I don't have anything from any expert saying that change in topography resulted in an increased flow onto the plaintiff's properties. Don't I need that for you to survive summary disposition?
What I need to be able to, I would agree that would be helpful to you in that respect. The problem is that my experts can't opine on that until they have additional information that would allow for them to know about what changed in the topography. I can only look as a layman. Again, I'm a lawyer layman, if you want to call it in that respect. I'm not an expert in those areas, but that information is necessary for me that I don't have, that prior counsel did not secure. And the reality is that unless I have that information, I can't offer an affidavit. And sure as heck, my clients who are lay individuals can't offer that expert testimony as well. But more importantly, the third part I guess I want to get at as well is I've come to learn is that immediately outside kind of the most immediate vicinity where water has traditionally been pulled into the culvert, which you've seen pictures of that, is that additional, what are they called, CPMs, corrugated metal pipes, have been added to help flow additional water from areas traditionally that have not been discharged into this culvert area is now being pushed into this area, which results in more water when you have these storm events to be able to actually push this higher volumes, and higher volumes, of course, behind a pipe creates higher velocity. And as a result of that, the evidence that I need to establish this is within, I believe, and that's what my affidavit provides for, is within the custody and control of the road commission. I wish my prior counsel would have asked for this information. I think she should have asked for this information. What I didn't hear from brother counsel was that it wasn't a one-way street where my predecessor counsel was demanding things of the road commission and getting things and then not getting things in return. It seems like a more of a dereliction completely in this respect. Again, I wasn't there. I can't speak to exactly what was happening or what the back and forth was on this, but from my work on this, I was before you, what is it, almost about 2 months or almost 3 months ago. Since that time, I've outlined that I've consulted with experts. I've reviewed the file. I've got up to speed on the whole thing on this respect, and I'm seeing where there's shortcomings as well. I don't want to give the court the false impression that I can come to this court and say like a magician, I can make things appear out of nowhere. I can't, right? I need the base material that is within the road commission's files to be able to give you the affidavit from our experts who can opine why their experts are either looking at the wrong hand, to extend the analogy out, or that perhaps the answer is that they may be right. But I don't know that until I have all the information from the road commission, which I simply don't have at this point. So I guess to kind of circle back to where I start, what do we do from here? Because I'm handcuffed. If the court doesn't give me some rope or some keys to unlock myself to extend the magician, I'm going to drown in Houdini's box in this case. Because I came to this case so late and so handcuffed, there's nothing I can do at this point unless this court is prepared to do that. So the question is how do we address Mr. Henn's fairness to him, that he should be able to have the chance to understand this case? I know the court, at least I hope the court.
I think he'd say he does understand the case.
Well, then he needs to explain it to me, because as I'm looking at his experts' report, his experts are focused on the wrong question. It's not the question of the size of the pipe. It's the amount of the water and the velocity of the water that goes through that pipe. And none of that is there. There's no study about the amount of water that's going through. There's no study about the velocity that's going through or the capacity that's going through. What it's focused on is again, the length. It says we put another extension on the end of this 24-inch culvert, and that can't possibly change the maximum capacity that's there. I don't disagree with that. In fact, I think that's probably right. But it's the wrong question. It's the wrong question, and you're being given an answer to the wrong question that's been framed here. I would like the opportunity to be able to present the right question and to provide our experts' testimony in that respect. So I am, in effect, and I will admit to Mr. Henn, and I'll admit to this court, I am asking for a bit of a restart. There's no doubt about it. I can't do it as a lawyer coming into this late in the game. I can't do it any other way. I'm stuck otherwise. And if that means that the clients have to be prejudiced by that because of what their shortcomings of their lawyer, then I guess that's the ruling of the court. What I am asking this court to do, and I'm giving this court my assurance on this, and I think I've built a good enough showing with you, at least of my work in the past, that this sort of thing will not happen again on my watch. What I would like the court to do is to allow me the chance to develop the case that I think the plaintiffs were trying to develop in this case from the get-go. Assert a theory that they probably should have asserted to begin with, which is inverse condemnation, which gets us all out of the immunity realm right from the get-go on all of this, which is the better way and the way I always pursue these kinds of claims when it's a surface water flood claim by a government official rather than a more complicated tort-based immunity blocking claim that exists. Allow me to get access to those records that I need to present our case. At the same time, Mr. Henn can remove all of his prejudice because as I'm hearing today, he didn't get all the information that he would have liked to have received. He can receive that through my office, and I will represent to the court that I will timely and expeditiously provide that information to the court and give us the chance to be able to present our theory of the case with the proper development of this case. And if the court feels that there should be compensatory remedy in this respect, I would point the court under 2.313 that you can sanction counsel and not the plaintiffs. Because what I'm not hearing is from Mr. Henn, and I think correctly so, is it's not the plaintiffs who dropped the ball. It was an officer of this court that dropped the ball. And this court can sanction that individual if the court feels that's necessary. I would ask the court, obviously, not to do that. I don't like asking. I don't like, lobbing the ball into another, counsel's shortcomings. But sometimes the facts are the facts, and these are the case, and these are the circumstances here. Perhaps, if the court is inclined to award that, perhaps a show cause order to Ms. Schaefer is appropriate rather than, simply addressing it here and now and giving her the chance to respond as to why she did what she did. Maybe there was a strategy. I personally don't see it, but perhaps there was a strategy on her part to obfuscate and delay. I will finish by saying to this court is that I do think, and I will represent the court as an officer of the court, I think there's a viable, proper, and compensatory awarding remedy for the plaintiffs in this case. If this was a close call case, I would simply withdraw on the case or withdraw the claims in itself. I think there's a solid case here, and I think that the evidence that's needed is not that it's not available out in the world for us to pick up. It's that it's in the files and records of the Road Commission that I need to get access to be able to develop. And if I get to the point again, and if you are gracious enough, which I'm imploring you, if I need to, I will beg you to give me the chance to have that argument at the right course. Because if I remember correctly, in the other case, I think this was the same complaint that prior counsel had had some shortcomings in the prior case with some discovery shortcomings, and I came in and had to plead with you and ask for a little bit of rope to be able to fix this. We will if the case doesn't pan out, I will drop the case. But I think the case will pan out, and I would not be pursuing it otherwise in this respect. One last point I will say is that one part I do disagree with brother counsel on is, yes, we are asserting a new claim, a new theory, but it's based on the same basis that's really there already, which is the idea that the surface water from a higher capacity with the change in the system itself resulted in a flooding of property to protect the public interest of the bike path and the roadway, and that an inverse condemnation isn't a brand new second claim, a whole unrelated claim. It's a slightly different theory to be able to get to the same substantive relief, which is a remedy for the mini Grand Canyon that got blasted into plaintiff's front yard from this flooding event. And the inverse condemnation claim has the added benefit of not being subject to this crazy multi-lever contraption of government immunity, with an exception to the government immunity that has seemed to have been stuck in this case from the beginning, of course, is why the Supreme Court took it in the first instance. So I'm not asking to recreate a whole new case. What I'm doing is simply saying I have suspenders in addition to my belt to be able to make arguments as to why the Road Commission is liable in these circumstances. I know I've been talking for quite a bit here. Unless the court has any questions, I'm imploring the court to give me the rope. I've proved to you in the past that I can exercise appropriateness, and if the court feels that sanctions are warranted, that you do place them against plaintiff's prior counsel. Obviously not myself. I don't think I've done anything at this point that's been a shortcoming. I didn't hear anything from Mr. Henn where my performance has been shortcoming. But at the same time, if you're not going to do that, it would be to sanction plaintiffs then a monetary amount, and don't use this case or use the current posture as a means to do a effective dismissal of the case going forward.
All right, thank you. Mr. Henn, you may not need it, but you have rebuttal if you wish.
I'm just going to say, Your Honor, what I heard Mr. Ellison say, and I will give him credit for making the best argument that I think he could possibly make on behalf of the plaintiffs at this stage. But he's testifying that, that a case has merit and that summary disposition should be denied based on what he's heard out there in the ether. And, where are the affidavits from the experts that he talked to that said, here's information that we think the Road Commission has that would, influence our opinion or that would provide a valid defense to the motion? It's just not there. And what is there is too much of just a speculative promise to deliver something that frankly could have been delivered, years ago if it was there to be found. And I don't want to get far off the record, but he's saying, well, someone told me that a flow valve was removed. I mean, this is a cross tube that is been around since 1958 and hasn't been changed except cosmetically with respect to this project. I mean, I honestly think the flow valve is, I think one of his clients said the road commission removed some plywood that somebody had jammed into the culvert as sort of a self-help mechanism. I don't know who did that. The road commission doesn't know who did that. I've seen cases where when people think a cross tube is causing them harm, they stuff rocks, they stuff bags of cement, they stuff old, steel rebar into culverts to try to impede the flow. And of course that's improper. But I mean, I just think to hear that example of a flow valve makes me think that, this really is fantasy on behalf of plaintiffs' counsel. And, I don't think at this point, after everything that's happened, that the court should indulge the plaintiffs in that. I also think that everything Mr. Ellison said about prior counsel, and I think the court hinted at this earlier, I mean, there is a remedy. There is a standard of care that attorneys have to adhere to. And if they don't, they can be held civilly liable to their clients, just like basically any other kind of professional. And, Mr. Ellison's arguments would work as well in that context. I think they would work better in that context than they work here based on what the road commission has been put through. And unless the court has questions, I think that's where I'll end.
Thank you, Mr. Henn. Mr. Ellison, any rebuttal argument from your end?
Yeah, I would just point out that the argument about the flow valve is not that someone stuffed a bunch of, that they went down and saw a bunch of pipes or cloth or rocks or plywood stuffed in there. This was a statement made by a road commission official, employee, that got conveyed to them as outlined in Mr. Kiefer's affidavit. So this isn't a matter of, I went down and saw something sticking out and assumed it was something that, in my lay opinion, as what it was. This was something from the road commission itself. I suspect, if given the chance, that those records would reveal that flow, which makes sense why it would never have flooded thus far. It would be a controlled, slow drip of water. And I'm going to say drip. It's not, with the 24-inch pipe, it's not really ever a drip, right? There's still a good amount of water going through but it would be a systematic flowing so that you would not have the overwhelming amount of water that comes into place. And that makes logical sense to me. And the reality is that, if then comes to find out where I've asked the road commission to provide this information, we didn't hear they deny it. They just said, we just don't think it's plausible. They didn't say it doesn't exist or it doesn't in that respect. I'd like that opportunity, because if they in fact change that flow system, that is going to be even more proximately related to the actual culvert itself, as opposed to the topography of the area, which is even more in tune with a sewage disposal event. So I'd ask the court, I understand Mr. Henn's frustration. I will even say I share in his frustration. I don't like coming to court begging judges to give me another chance because of screw ups that were not of my own making. But I am here asking for that. And I feel strongly enough about this that I've decided to help these individuals take a case that was on tough procedural grounds where we're at, because I do think there's merit to these claims. Thank you.
All right, thank you. This case was filed initially back in 2020, but this court granted a summary disposition to the defendant on governmental immunity on the accrual date or timing of the claim back in July of 2020. And it didn't really come back to me after remediature of the record until a status conference in November 27th, 2023. So that, 2.5 year delay is, if it's anybody's fault, I suppose it's my fault for making an incorrect ruling that had to go all the way up to the Supreme Court to get reversed. But then at that point, there were scheduling orders entered, discovery began. The plaintiffs did not really participate much in that, if at all. Looks like they didn't even file their initial disclosures, or at least the supplemental initial disclosures. despite court orders compelling that. And eventually plaintiff's counsel got out of the case, and Mr. Ellison is in the case and wants to sort of reset. So we're now past more than 1 year after we've had it back on remand. The defense has gone forward and litigated it sort of on their own, so to speak, and gotten their experts and done what they could without the plaintiff's participation. I suppose you could say, well, gee, it's kind of easy to win a game when you're the only one playing, but the plaintiff has to present something here. I have several motions. The first one I'm going to address is the road commission's, the defendant's motion for summary disposition. I am going to grant that motion under either 2.116 C7 as it was filed, or consider it as a C10 motion. Either way, you're allowed to consider the affidavits and other evidence in the motion. And the defendant says the plaintiffs haven't established an exception to governmental immunity, so it's C7. Whether to get there is to say they haven't raised a genuine issue of material fact about that exception. So I guess we'll call that both a C7 and C10. But here, it's more than just the length of the culvert. I did review the attachments, and the defendant has come forward with a hydrogeology expert that explains that not only did the work on the culvert not cause the overflow event, but that scientist explains a mechanism that likely did cause. And he says to a reasonable degree of scientific certainty, what the road commission did out there did not cause this. What did cause it was historically increased rainfall, soil that is particularly susceptible to erosion, and a storm event that caused that. I have the civil engineer's report or affidavit explaining that the road commission is not at fault for what happened. I have statements from a surveyor about, they're not expert topographical analyses, but it's at least something saying that there's been no change to the overall topography or conditions out there. And in response to that, I have nothing from the plaintiffs. I have the plaintiff saying, well, I've heard this, or I believe this might be the case. Even Mr. Ellison, you know, he is he is an accomplished attorney in the area of property law. I guess I can say that with confidence, not only based on my dealings with him, but his dealings on pretty important cases around the state. So I'd love to have another case where Mr. Ellis is involved in it, but it's not going to be this one. He says, if this case doesn't pan out, I'll dismiss it. I mean, that's really wanting to go back in time now 5 years to the beginning of the case and say, we're just gonna, get into this case and see what we got. And that's not how this needs to work. I don't even have an affidavit from any experts from the plaintiffs saying it's possible that a change in topography would have caused this. And if the records show XYZ, that could have caused it. We need to get in there and look at those records. I have nothing. I just have a plaintiff's attorney saying, let me have a crack at it. And if there's nothing there, I'll dismiss. But I think there's something there. That's not the kind of response to a motion for summary disposition that survives a motion for summary disposition. The moving party, the defendant, has come forward showing that they are not liable for this, and the plaintiff has not rebutted that. So that doesn't satisfy the non-moving party's burden of coming forward to raise a genuine issue of material fact. So I am going to grant summary disposition to the defendant under 2.116 C10 and or C10, C7 and or C10. In my judgment, that means I don't need to reach the issue of dismissal as a sanction. So I won't reach that question other than to say, if, for example, I was again reversed on appeal substantively, there are grave and serious discovery violations that do demand a remedy. I'm not deciding today whether dismissal is the appropriate remedy. It may well be that a compensatory remedy would suffice. I'm not going to engage in the complicated weighing that I would need to for that, because anything to that effect would be dicta. I do have the plaintiff's motion to amend the complaint, and as I understand it, I should allow them to do so unless it would be futile. And I do find that it would be, because as the plaintiff's attorney mentioned, it's a new legal theory, but it's based on the same factual claims. And those have been buttressed by no evidentiary, expert, or scientific support whatsoever. And there's persuasive scientific evidence to the contrary. So it's really the same type of claim, just in a different legal costume. So that would be a futile amendment. So I will deny the motion for leave to file a second amended complaint, and therefore would deny the motion for additional discovery. And Mr. Henn, as the overall prevailing party, would you submit an order?
I will, Your Honor.
All right. Thank you both very much.
Thank you, Your Honor.
Thank you, Judge.